My name is Volker Kruger, and I'm joined by Janus Olivier to talk about a recent constitutional court decision pertaining to life partners and maintenance and inheritance, etc., which I think is rather important. And Janus, thanks for joining us. And maybe before we get into this case specifically, you could perhaps also deal with the background of the relevant legal developments over the last couple of years. We've done a previous program as well, you and I, to discuss this. But I think this is a very important development.
Yeah, Volker, I agree. We now have the long-awaited Constitutional Court judgment, Banya versus Master of the High Court, and others. So the background that you referred to, it started with same-sex couples living in permanent relationships or permanent partnerships that they call them, who initially weren't allowed to inherit from one another in terms of the Interstate Succession Act. They weren't allowed to claim maintenance in terms of the Maintenance of Surviving Spouses Act, because of course they were never married. We should keep in mind that our legislation didn't allow same-sex partners to get married up until the Civil Union Act in 2006. So the history in respect of same-sex couples started with the very important judgment, all of whom were also in the Constitutional Court. That was Gotti versus Culver in 2006. That specific case dealt with the Interstate Succession Act, and the Constitutional Court, they found that it was actually unconstitutional for the Interstate Succession Act to not allow spouses or partners, rather, in permanent same-sex relationships to inherit from one another, importantly, where they have undertaken reciprocal duties of support. So the Constitutional Court there in 2006 already sort of, in that order, allowed partners in a same-sex relationship to inherit from one another in terms of the Interstate Succession Act. The following words were just added after the words spouse in the act. It's just then, as we said now, a partner in a permanent same-sex life partnership in which the partners have undertaken reciprocal duties of support.
So you have to be in that category to qualify. No? It's not just any life partner. It must be a life partner where there's an undertaking of support. No?
Yeah, of course. I cannot know you for a week or 2 weeks and claim if you now pass away, we were in a permanent life partnership. There must, of course, be some proof. And then I think the reciprocal duties of support stems from the fact that in a marriage, you legally have a duty to support one another, and that duty isn't there when you're just in a permanent relationship. So that's why the court said, if you want the same rights as a marriage, you must at least then have taken on the same obligation voluntarily that you undertake this reciprocal duties to support one another.
Okay.
Yeah, so that was the Gotti versus Culver case, specifically dealt with interstate succession and not with maintenance in terms of the Surviving Spouses Act. Then we look at the 2016 Loubser-Eno versus Dublin and another. So this is now after the Civil Union Act came into effect, which was later in 2006. So just after the Gotti versus Culver matter, the Civil Union Act now actually catered for same-sex couples to get married. So up until that stage, they were entitled to inherit if they weren't married in terms of the Gotti versus Culver case, and they were also entitled to get married and then also inherit in terms of the original wording of the Interstate Succession Act. So there was a bit of eyebrows raised from opposite sex partners in a permanent relationship who said that, okay, but same-sex partners are now at an advantage because they can still inherit even if they are not married, whilst we as opposite sex partners, we still have to get married. In this Loubser case that I referred to now, the Constitutional Court just confirmed and said, yes, it is indeed the fact that same-sex partners might be at an advantage, but there will be an appropriate time to resolve that issue, and this is now the case that we're dealing with, this Banya versus Master of the High Court. It is the appropriate time to deal with. So that's why I said initially it's a long-awaited judgment. So I can maybe briefly give the facts of this Banya matter. It was a Mr. Roux and Miss Banya. They were in a romantic relationship since 2014. They moved in together. They attended social gatherings together. Mr. Roux referred to Miss Banya as his wife. If memory serves from the judgment, they also said he referred to Miss Banya's brother as his brother-in-law. So it was clear that there was an intention for a permanent relationship. He paid for everything, and she only provided him with love and companionship in terms of the judgment. In 2015, they got engaged, but in April 2016, unfortunately, Mr. Root passed away. In his will, he still left everything for his mother, but she also passed away in 2013. But then, of course, Ms. Branya was left for nothing. Well, with nothing rather. So she instituted a claim in terms of the Interstate Succession Act and in terms of the Maintenance of Surviving Spouses Act. Both claims were, of course, rejected, and I believe rightly so, by the executor at that stage, because the law simply didn't allow him to do that. And then she took the acts, I would argue, to the court and said the court must please declare that both of these acts are unconstitutional because they are prejudicial towards her. She's not allowed to inherit or to claim maintenance simply because of her marital status. So we must keep in mind, Section 9 of the Constitution says no one can be unfairly discriminated against based on their marital status. So the High Court, in essence, that was in the Western Cape, found that the wording of the acts are indeed unconstitutional. It discriminated against Ms. Branya on the grounds that I just mentioned now, but because it's a constitutional issue, the judgment was referred to the Constitutional Court for approval, and this is now the judgment that we have received. So in the Constitutional Court, I won't bore you with all the arguments, but important for us and important for the listeners, the court confirmed the High Court order, and it now said both in terms of the Maintenance of Surviving Spouses Act and in terms of the Interstate Succession Act, both were found to be unconstitutional by not allowing permanent life partners to inherit. So important, I would argue, to remember is the Constitutional Court no longer differentiates between same-sex and opposite-sex life partners. It just says permanent life partners in the relationship and where they have undertaken reciprocal duties of care. So that's the importance of this judgment, and it's it's going to change the way we administer the deceased estates from here on out.
Yeah, and it's the Constitutional Court, no? So it's the final verdict on this matter, which I think is good news. No? The uncertainty that we had over the last couple of years wasn't good. So now we have the judgment of the Constitutional Court, so there's no doubt that if you fall into that category as a life partner, as we explained, I guess one could also say it's where you basically live together as if you were husband and wife. No? So you have the same undertakings, etc., and as if you were husband and wife, and then flowing from that, you enjoy the same rights and you have the same obligations, including maintenance obligations and including the right to inherit as an interstate heir in terms of the Interstate Law of Succession Act. Obviously, if there's a will, that will still be given effect to. No? So if, for example, the life partner is not mentioned in the will, everything goes to the children, then that will would have to be executed. However, the life partner could then potentially, in such a case, lodge a maintenance claim against the deceased estate, I would think. No? Do you agree?
Yeah, no, exactly. So that's where this, if we say Mr. Roof's mother was still alive and she wants to inherit in terms of the will, then Ms. Branya would have still been successful with a claim for maintenance, as you rightly pointed out now, Volker.
Yeah, and that claim then depends on the size of the estate, the ability of the surviving life partner to maintain herself, the duration of the marriage, etc. So your typical criteria that is considered if a maintenance claim is instituted. So that would also obviously depend on the circumstances, whether and to what extent there would be a maintenance claim in such a case. All right. Thank you, Janus.